With us, we have four speakers, Professor Victor Katan, Professor Daphne Richmond-Barak, Professor Sharon Weil, and Robert Neufeld of our own here at the Minerva Center. My name is Itamar Mann, and we are here today, as you know, to discuss the Palestine situation at the International Criminal Court after the prosecutor has decided to go forward with the investigation of the situation in Palestine. The political conditions here in Israel are such that we are before elections. We are really running towards another election in a couple of weeks. And the ICC investigation really comes, at least from a domestic perspective within that context, and has created, I think, a considerable debate and outcry, and also various allegations of anti-Semitism by the investigator, with which my own opinion is, of course, that they are completely baseless, but it is the context in which we are discussing these questions today. I will present the speakers each in their own turn before they before they speak. The first speaker that we have with us today is Professor Victor Katan, who is a senior research fellow at the University of Nottingham. He has written widely about questions of international law related to Palestine, and also from a historical perspective. Among his publications, you will find The Palestine Question in International Law from 2008, and From Coexistence to Conquest, International Law and the Origins of the Arab-Israeli Conflict, 1891 to 1949, from Pluto at 2009, 2 books. Recently, Professor Katan has contributed to this particular debate on the pages of the newspaper Haaretz in a very interesting, in my view, article. And it is to some extent following that article that we thought that it would be really wonderful to have you with us today. So I guess what I'd like you to speak about to kind of start us off with this conversation is to give us some kind of context where we stand right now, what kind of a little bit of a background for listeners who might not be as familiar as some of us, and also to discuss, I think, this moment against the backdrop of a certain context in which the Palestinians have, for a certain period of time, a certain history now going back more than a decade, attempted to, I think, pursue a liberation struggle through international law. And we'd like to hear from you a little bit about the opportunities that international law has provided for the Palestinian national struggle and the struggle to end the occupation, as well as perhaps some of the inadvertent results that might ensue that might not have been entirely expected at the outset. Thank you for being with us again.
Thank you, Itamar, for the invitation and for your questions. So I guess what you're asking really is about the Palestinian strategy before the International Criminal Courts, and I guess the liberation strategy for international law. And to the extent that one can discern that there is any strategy, I would probably describe it mostly as responding to events, in the sense that if you look back to the 2004 Wall Advisory Opinion and the 3 attempts to join the International Criminal Court, as well as a self-referral, these were all responses to events on the ground. So in 2004, it was obviously the construction of the separation barrier wall. In 2009, when the first attempt was made to lodge a declaration was the registrar of the International Criminal Court. It was during Operation Cast Lead. There was then another attempt in November 2012, when Palestine was given an observer status at the United Nations, and lots of countries were concerned that Palestine might use that to join the ICC, and you can see those discussions at the UN General Assembly and in the British House of Commons. One of the reasons why the UK didn't vote in favour of that resolution, because they didn't get the kind of like a promise not to join the court from the Palestinian Authority. And then, of course, during the war in Gaza in 2014, there was a huge pressure on the Palestinian leadership to join the court, which they eventually did in January 2015. So again, that was a reaction to a conflict situation in Gaza. And then in 2018, there was the self-referral, which took place during the Great March of Return, the protests in the Gaza Strip. So in that sense, there hasn't been, if you like, a grand strategy at all. It's always been haphazard, sporadic, and piecemeal in responding to situations. However, there has been a shift in Palestinian approaches, the liberation movement's approaches to international law more generally, especially following the 2004 Wall Advisory opinion. And I don't know how well this is known, but actually that opinion was the language that was used in the General Assembly request for the advisory opinion was very similar to an early attempt to refer a similar question to the International Court of Justice in the early 1980s. That was drafted by the governments of Egypt and Jordan, and it was about the settlements. So in the 1980, when the Likud came to power, the Begin government vastly expanded the settlement project, especially in Jerusalem. And there was a series of Security Council resolutions condemning that. And the Egyptian and Jordanian governments wanted to go further and follow it up with an advisory opinion that would have asked what are the legal consequences of the settlements, considering the Fourth Geneva Convention and other rules of international law. But at that time, the PLO opposed it. So when it was raised at an Arab League summit in North Africa, the PLO was against it. They saw these international institutions as kind of like imperialist and unhelpful. And of course, they weren't happy that it was being proposed by Jordan. They were still struggling about who was the official representative of the Palestinian people. So once that was all resolved, we see a shift in terms of strategy in the 1990s and especially in the early 20th century. And I think that also has a lot to do with the building of institutions in the Palestinian Authority and the establishment of technical offices and the hiring of expert consultants and hiring of Palestinian expatriate lawyers who were able to provide this kind of advice. But it didn't mean, of course, that there was a strategy as such. And with regard to the current, the latest announcement, yes, it is, of course, a very important step for the Palestinians, so the opening of an investigation. But there will be, issues, which I think I mentioned in my Haaretz article with regard to accessing the Gaza Strip, with regard to the relationship between the two political movements in Palestine, principally because only one of them is going to be the subject of an investigation. Not to mention that there may be elections happening also in Palestine, which could also throw up further complications. But I can discuss perhaps more of these issues when the other speakers have commented. Thank you.
Excellent. That was a great start, and I was taken by the description of a transformation from a kind of anti-international law position to this kind of very significant embrace of international law by Mahmoud Abbas, which I think is remarkable and also can be regarded perhaps critically. And I think, part of what we would like to think about is whether that seems like a good move or not from also the perspective of Palestine's liberation struggle. I am moving, however, now quickly to Daphna Richmond Barak, Dr. Daphna Richmond Barak from the Lauder School of Government Diplomacy and Strategy at Interdisciplinary Center in Herzliya. Daphna Richmond Barak has also published on the ICC investigation. It's the possibility of the ICC investigation, and has responded. And I believe you were also among the drafters of one of the interventions that were submitted. But correct me if I'm wrong. Daphne Richmond Barak published her book Underground Warfare, which is about the tunnels campaign coming from Hamas and risking the security of Israel, which also is an award-winning book, and had some considerable kind of clout recently in the international legal discussions around these issues. Daphne, I would like to kind of ask you, after this recent decision to indeed open the investigation, some of the commentators are still holding up questions regarding the basis for jurisdiction. And in general, I think for many of us, many questions about the scope of jurisdiction, including the temporal scope of jurisdiction, are still very much open. And I'd like to invite you, if possible, to offer us some reflections on these continued unknowns with regard to what this kind of investigation entails. The floor is yours. Thank you.
Thank you very much, Itamar, and thank you to the Minerva Center for organizing this event. It's really interesting to hear, to hear and to discuss this. And I actually am very interested by what Victor just said about the legal strategy, because I've written quite a lot on what I view as a very clearly set out strategy that is very consistent, step by step, but towards a very clear goal of gaining access to UN institutions and international judicial institutions in an incremental fashion, step by step, for the past 2 decades. So I was fascinated, Victor, to hear that you think this is actually a bit sporadic, as you said, and kind of a function of events. Very, very interesting take that I never saw it this way. So that's really remarkable for me to hear. Let me talk to you a bit about these unknowns. So yes, there was the PTC, the pretrial chamber decision, which paved the way, or kind of closed the way, for the prosecutor to open the investigation in a formal way just very, very recently. So that's done, and in a way, it's a clear announcement. It's a clear step. It's going to happen. It's happening. There's nothing to say about this. But, however, there are still pending questions, a lot of unknowns, and I, just will highlight them briefly, and maybe we can take them on sometime later in the discussion. The first thing that is still kind of like in the open is what will Fatou Bensouda, the prosecutor of the ICC, do before, or what actions will she take before she leaves office in June? There's a couple of things she can do, and there's some things that she actually said she might do. In an interview a few months ago, she mentioned that she might release a couple of follow-up reports, including on the issue of complementarity after the judges provide a ruling on the scope of the court's territorial jurisdiction. So if that's the case, and if she really is planning to, maybe she has these reports that she's been working on in parallel to the, as the PTC was working on its own decision, then we can expect maybe some of these to be released quite soon, I guess before June. And that could be really, really interesting, and potentially also, affect the conduct of the investigation and what the next prosecutor, Karim Khan, might be able to do. Another thing that is up in the air is what will happen with the assessment of complementarity with respect both to Israel and to Palestine. So on Palestine, the prosecutor kind of dismissed very, very quickly the complementarity issue, saying that it was irrelevant with respect to the Palestinians. It was done in one sentence without a lot of explanation. I'm wondering, are we going to get more on this with respect to what complementarity means for the Palestinian Authority or for Palestine? But with respect to Israel, and this is an issue that has been raised in recent days by Nick Kaufman, a very important question. When will the prosecutor choose to issue these letters to states that are the more natural fora for the prosecution and investigation of the alleged crimes with respect to complementarity? There's been a call for waiting until the Israeli elections that you mentioned, Itamar, in your opening statement, for them to pass, for the Israeli government to be elected, composed, put together. For this to happen, will Fatou Bensouda wait, or will she do it? What does this mean for Israel in terms of having an opportunity to really address this complementarity question quite seriously and in a kind of a quiet fashion, outside of all the election noise? Another unknown, and again, I'm running quickly, is the possibility that issues regarding territorial jurisdiction or any kind of jurisdiction, and I would really like to see temporal jurisdiction discussed at some point in this investigation. The PTC said in paragraph 131 of his decision, can be brought up later on in the proceedings in accordance with Article 19.2 of the Rome Statute. Will this happen? Will jurisdiction be challenged later on in the process? Meaning, are we done talking about jurisdiction here, or are there going to be further opportunities or challenges to jurisdiction down the line? Finally, the last point I want to mention here, with this respect, is that there's a lot of questions regarding Karim Khan, who's coming as a new prosecutor. How does he view and how does he interpret his obligations under the Rome Statute with respect to review of the material that has been gathered by, as the part of the preliminary investigation, etc., by Fatou Bensouda and her team? And how will he also interpret the kind of directives from the independent expert review, this really long 300 and something page report that was issued recently about the work ethics and so on of the court, and also its priorities? It seems that the court is really at a crossroads in terms of wanting not only to establish its legitimacy, but also setting up priorities. If you pay attention to the announcement of Bensouda on the opening of the investigation, on the second sentence, so it's not the last sentence of her announcement, it's the second sentence of her announcement, she says, how the office will set priorities concerning the investigation will be determined in due time in light of the operational challenges we confront from the pandemic, the limited resources we have available to us, and our current heavy workload. So it seems that all these issues are still out there, they're weighing, and they are likely to affect what we see next.
Thank you. Thank you so much. Next in order of speakers is Robert Neufeld, who is a postdoctoral fellow. Dr. Robert Neufeld is a postdoctoral fellow here at the Minerva Center for the Rule of Law Under Extreme Conditions. He is conducting a research together with Professor Eli Salzberger and Professor Shlomo Mizrahi on the regulatory framework for Israeli emergency laws. But he is also a very, very experienced military lawyer. He served in numerous positions in the Military Advocate General Corps and the Military Ombudsman, including commander of the IDF's School of Military Law, head of the Operations Law Branch in the IDF International Law Department, legal advisor to the Israeli Air Force, Israel Navy, and IDF Home Front Command, chief regional military prosecutor, judge advocate for the Israeli Air Force, legal advisor to the Intelligence Directorate, and legal advisor to the Technology and Logistics Directorate. Robert has also, I believe, been one of the authors of one of the submissions to the ICC with regard to the question of jurisdiction, I believe working with Shurat Hadin. And I would like to ask you, Robert, to give us your perspective on what does this investigation mean in terms of the possibility that it will actually go forward. I mean, we talked in our preparations for this conversation about evidentiary questions, whether there is any chance that Israel will cooperate with this investigation and provide evidence. If not, what does this mean about the likely results of this investigation, and how will it look in your, according to your assessment, as a practical matter, if that's okay?
Okay. Thank you so much, Itamar, and thank you for the opportunity to be here and to speak here. I think basically the point that we'll try to present in the next few minutes is that even after bridging the issue of jurisdiction, and Daphne correctly said it's not surely bridged at this point, the upcoming ICC investigation and potential indictments which will follow, whether against Israeli soldiers or even against armed groups in Gaza, will face tremendous challenges. These challenges may not only undermine the prosecutor's investigative work and chances for a fair trial, but they bring both Israel and Palestine into a very, very difficult decisions they will have to make further down the road as to the extent of their participation, whether direct or indirect, in these proceedings. There will be a duality in both, I think, Israeli and Palestinian approach. Israel's strong opposition to the investigation will be countered by competing interests that may push Israel into some degree of cooperation, and vice versa with the Palestinians. The warm support of the investigation may be faced with interests which will not to cooperate, maybe to say the least in some cases. I think a good starting point to this discussion, it will be in a note that Judge Kovacs left us in the dissenting opinion, saying that, quote, "I am convinced that without the cooperation of the directly interested states and in the present and truly complicated, over-politicized situation, the prosecutor will have no real chance of preparing a trial-ready case or cases." Well, Judge Kovacs' note does not come out of the blue. The prosecutor has already failed before in cases she or her predecessor brought in evidentiary problems. But here, I think the situation will not remain only the prosecutor's problem. In some perspective, an ICC investigation will inherently provide lesser protections for Israeli officers under such an investigation compared to Israeli judicial system. In a situation where Israel does not cooperate in such an investigation or trial, this can become even dangerous for defendants or people investigated, and put Israel in a very tight spot. To explain my opinion, I'll need some minutes because I'll give some details or an example. I'll present a possible incident that may require a decision whether to investigate or during investigations and even to an indictment. I'll try to do some comparison between the Israeli procedures and regulations as to criminal investigation of operational matters post the Turkel Commission report, which reformed these proceedings, and the ICC investigation in this case. The comparison will help explain challenges that will arise both to the OTP, the ones that need to defend themselves, for Israel, Palestine, even Hamas, throughout the proceedings. I will talk about three issues. One, the first will be a disclosure of information regarding national security. The second will be the way the issue of operational debriefs as an example from some clashes between investigations and Israel or domestic legislation. And third, which the first two are more like Israel concerned, but the third would be the potential outcomes of the ICC's limited access to crime scenes, evidence, and witnesses, and the dangers that may arise due to potential third parties investigations that the prosecutor may think of using in this case. So let's take an incident which concerns the bombing of a civilian house, due to which several civilians found their death. The fact that civilians died in a bombing does not immediately tell us there is a war crime that has been perpetrated. Under IHL, civilians may still find their death as collateral damage, and if the attack against them was against a military objective, the attacker complied with IHL rules, including taking the necessary precautions and correctly assessing proportionality, this tragic death will still not deem the attack as illegal. Now, all this must be assessed as to what the commander knew or should have known when making his decision. Now, this is a theoretical example, but not far from cases that the prosecutor has already, without telling us the whole incident, already said she will be going into, as she referred to, at least for one case, from unproportionate attacks. Now, let's say the commander got this information for a very sensitive intelligence source, and according to that source, the civilian house was used as a military objective. There were two things there. There was let's say, a hub of a highly secured phone system used to coordinate attacks, and a weapon depot. The hub was the more valuable target, but the IDF declared that it attacked only a weapon depot to conceal the fact they knew the map of that secure line system. Okay. According to commander assessment, there should have been less civilians there, making it, through his opinion, at that point as proportionate. He then reports and gives all this information in his debrief to his superior. Of course, the remains of that secret hub have long been disposed by Hamas, and nobody can really know more than that information that was brought to the commander. So this case does not present a prima facie criminal behavior, such as like execution of a detainee or looting or such cases. In this case, which was being investigated or in Israel, it will go first to the fact-finding assessment apparatus, which will gather the information, including the operational debrief, including the raw intelligence information, and bring it to the prosecutor to make a decision. Now, the ICC will not have this intelligence information. It is unlikely that it will decide to proceed with an investigation just by reading the military advocate general's short, censored report saying that it was a military objective and the unfortunate number of casualties was unpredictable. So what will Israel do? For the one hand, Israel may decide not to cooperate, either for legal or tactical reasons, or even because a true reluctance to disclose some of its most sensitive intelligence sources. It is one thing to present these sources to an Israeli judge. I've done it personally many times, but it may be considered different showing it to an alien, to the ICC. On the other hand, Israel wants to protect its soldiers, so it may prefer that no investigation would even begin in such a case. Now, there are ways under...
I just interject very shortly to say that we want to have this, if you can reach concluding remarks for this particular intervention, and then we'll get back to you, if that's okay.
Okay, so there are ways under the Rome Statute to deal with disclosure information regarding national security. And these ways are the Rome Statute. If you refer, for example, to Article 72, try to make the states to do all reasonable steps to be taken in conjunction with the prosecutor, with the defense, with the pretrial chamber, and at the end of it, if nothing succeeds, the court may, if going further on, may make such inference into the trial as to the accuser, to the existence of non-existent of fact. This may result in tensions between the state and its officers who are investigating or even standing from trial. It will, they may even prefer themselves that Israel disclose this information. Now, this is one possible example. There will be cases on the complete opposite, where Israel may find itself on the other side, where information has already been provided to the prosecutor that regards national security. It is Israel who will try to avoid its disclosure. So, Itamar, do you want me to stop here and just?
Yeah, I think this is a good point to stop. I think you made some very interesting points about this procedure.
Anyway,
I have my own questions, but follow-up questions. But I think I'll wait for the next round for that. We just want to hear everyone for a first kind of short set of thoughts, and we have and once again it was quite informative. Next, we have with us Professor Sharon Weil, from the American University in Paris. Sharon is an expert on international humanitarian law and law and terrorism. She works from a socio-legal perspective and socio-political one. And she is the author of the role of national courts in applying international humanitarian law from 2014, and co-editor of the book Prosecuting the President, the Trial of Hissène Habré. For Sharon, who has written recently about the kind of public debate in Israel surrounding these issues, I ask a little bit of a different question, which is to reflect on this public debate, on how it has developed, on the roles of different actors. Does it connect to any particular transnational trends concerning backlash against certain international institutions? And perhaps more generally, how do you understand, from your perspective, the internal debate in Israel in the domestic level and its relationship to the kind of transnational and international context? Thanks to you as well for being with us. It's a great pleasure having you.
Thank you, Itamar, and thank you for inviting me for this very interesting roundtable and for all the participants. So what I want to do in my 5 minutes, I want to try to have a real argument, so I will do it quickly. We could go back to it later on. So I would like to look at the essence of the main reaction of the Israeli government after the announcement of the investigation and the way it collaborates all the way. And then to situate it in a comparative manner to other rule of law states that found themselves in a similar situation at the ICC. So, of course, I can think of the US, of the UK. We were also under preliminary examination. So if you want, there is a kind of a scale of reaction that we can observe. On one extreme of the scale, you could see the US, when the prosecutor announced the opening of the investigation, which, was later authorized by the pre-trial chamber. Then it was a very extreme reaction. It was extremely delegitimizing the ICC. There was absolutely no legal dialogue with the ICC. It was sanctioning at personal level, the ICC prosecutor, etc. So it was a very, very violent reaction and not at all in a legal dialogue. Then on the other way of the scale, you could see the UK that found itself under a preliminary examination for allegation committed in Iraq for a very, very long time. So it opened, it closed, it opened. Now it closed recently in December. But during this entire time, the UK, European state, party to the Rome Statute, financing the Rome Statute. So this is not the kind of discourse, like the destroy discourse that we can find. So it's more a collaboration, opening of dozen examination, investigation, all kind of thing in order to comply with complementarity until finally we have the decision not to open an investigation. So just to make it clear, I mean, the UK, US, and Israel has all the same objective, not to reach the ICC, right? I'm not saying that any of them is better on the other, but there are different ways of collaborating with this, or not collaborating, different way of addressing this institution. So when we look at the way Israel reacted, I can really situate it somewhere in the middle, So you have those delegitimizing arguments, First of all, the very emotional one, we are the victim. The ICC was created to prosecute Nazi-like crimes. Of course, we are the victims, therefore we cannot be the perpetrator. And this is not a court for us. We are the victim, and we are the victim also of terrorism, and etc. And this is an anti-Semitic, So this is one way of delegitimizing. Another way of delegitimizing is to use, the politics of the court, the double standard argument. They don't persecute Syria, they don't persecute Iran, but they go after us, which is, of course, a valid argument, the double standard argument, and no one can negate this, but we know that the court cannot establish its competence over those states. And then we have, therefore, we will fight in all our might, etc. So this resembles a bit to the US. But more important in my view is the dialoguing argument, okay? So first of all, yes or not state, we have jurisdiction, we don't have jurisdiction. I mean, this is a legal engagement with the court. So you convince people to send amicus brief to the court. So how can someone say that Israel is not collaborating? I mean, the question of collaborating is not even, should not be asked, because Israel is collaborating with the court. When you have the legal advisor, the attorney general putting an entire opinion of dozens of pages on its website. So even though it's not like official collaboration, of course it's a dialogue, it's a collaboration with the process. And I think that Israel is thinking that they should collaborate, because they saw what happened with the UN fact-finding missions when they did not, at least did not officially, because unofficially we know they did. But it was always saying, listen, you need to present Israel argument, because then you can influence the decision. I mean, if you don't bring your case, how can you win it, So Israel is in a kind of trapped of between these two attitudes. So what can we learn from this? So when we read the Israeli press that since a month ago, when we had the pre-trial chamber decision, we could see that the press, and frankly, I was surprised to read this press. So I asked Itamar, and he had a very kind assistant that sent me all the press item in Hebrew, and I read it quickly. And I was, let's say, quite surprised how seriously it is taken in Israel. Even in a kind of really afraid and saying, we have a list of 200, 300 people that might be prosecuted, and we will not know because it's secret. So what will happen if there will be arrest warrant? What are we going to do? Etc. So in this sense, we can see that there is a real impact. And then lastly, we need to think, okay, so what next? Okay, so we heard a little bit the person before me speaking, and etc. So, I mean, you can choose the complementarity approach for Gaza. It will probably work. But then we know, and everyone knows, that for the settlement it won't work. It simply won't work. So then the question, what next? And here I want to propose you a comparison to Colombia. And I think this is the real comparison. And this is also a way where we open a door to a positive process, perhaps the beginning of the transitional justice process. Because why not to think about having a peace process could actually block the ICC. And perhaps this is the solution, but in a sense, why don't we start to think seriously about doing a real peace negotiation where the balance of power maybe now a little bit more balanced because of the interference or because of the role of the ICC. And I think that if we will go to this direction, it can be really interesting. And again, I can then propose you to look at what is going on in Colombia, because Colombia has been involved for 50 years in a non-state armed conflict with different armed groups. So, of course, it's very different from Israel and Palestine, but it's similar in the sense that both sides are going to stay here. It's not the UK going to Iraq or US going to Afghanistan. It has nothing to do with those kinds of conflict. It's more like Colombia, that the FARC and the state will stay here. Israel and Palestine, everyone is going to stay here. So I don't think, someone even think otherwise. So the thing is that perhaps this could be an opportunity. And in the case of Colombia, we saw the ICC since 2004, when it opened the examination, he didn't go to investigation because we have several peace processes that started and establishing transitional justice process. Okay, I hope I was not too much for 5 minutes. This is what I had to say.
Very kind of provocative, of course, to transfer the Colombian peace process to here. Well, that also raises a host of questions, but it was very interesting. Thank you. I have actually questions for each one of you, but because I think that there's already a kind of relatively long queue developing in the chat, or even a kind of parallel conversation in the chat, I'd like to transition now to giving each of you an opportunity to ask another panelist about their intervention, or to comment about the interventions that have been proposed thus far. If any one of you would like to do so, Victor, I see your hand.
Thank you, Itamar. Yeah, I have a question, I guess, for Robert. I think it's also been raised in the chat box about the issue, and I think Sharon mentioned it as well, about the settlements issue, and the possibility, there being no complementarity, and how would how do you think the court would be able to investigate that issue? What kind of things would it be looking for? And then I guess a question also for Sharon about the peace process in Colombia. Can you say more about that? And how it's similar or different to the failure of the negotiations between Israel and the Palestinians? What's the parallel there? I'm not familiar. I'm so familiar with Colombia.
Yeah, let's start off with Robert.
Yeah. So first of all, you said ask a question, and I have no questions to all the panels because I definitely agreed with everything that they said. So everyone brought this perspective, although it may lead to different conclusions, but I think it's very insightful, very insightful presentations. The settlements, of course, it's not. I did not have time to speak about all the other issues and problems that an ICC investigation may have. And there's no question about the fact that the gathering of evidence as to the settlements, which can start with Google Maps, it's much easier than other issues. But it goes back to things that I was saying, that this also may lead Israel to rethink its opposition from the other side, because I'm sure Israel has some information regarding some Palestinians' involvement, and this is exactly what I was saying. Both sides we're starting a journey now where both sides will find themselves with conflicting interests on the way on this long road that will go now. Sometimes wanting to cooperate with the court, sometimes trying not to cooperate with the court. The initial step, the initial position at the beginning, will probably remain most of the way, unless something very remarkable happens. Both sides will remain with this initial position, one rejecting and the other accepting, but both sides will change positions in nuances that will follow to protect their interests and to counter others' interests. The settlements, no question, is the Achilles heel in Israel's ability to defend itself, because collecting evidence in this issue can be relatively easy to some point. And that will raise again questions of jurisdiction and back to things that Daphne mentioned, and maybe trigger some peace talks. It's like I heard, by the way, Sharon, Luis Ocampo having the same thought about where this investigation can lead. Exactly the same thing in another panel I've seen him participate into. So that's it.
Yeah. I mean, I'll just offer that in my mind, and I don't know if others agree or not, the question with regard to settlements is more really a question of the interpretation of the law. And Article 49 of the Fourth Geneva Convention, whether it is creates a kind of criminalization of these particular settlements in the context of the now, again, quite strong interpretation here in Israel that regards this prohibition as not applicable for various reasons that have to do with the interpretation of the language. Of course, I think it's also fair to say that clearly in terms of the intention of the framers of the Rome Statute, the settlements are indeed within the scope of the statute. But with regard to the complementarity issue, I have to say, frankly, I didn't, and I'm really apologizing if it's my own shortcoming. I didn't really understand entirely the answer, Robert. Is it that basically there is no complementarity concern there?
Wow. Again, should be. You just answered the question with your first word. There is the issue is mostly of legal. I was referring in my presentation as to the collection of evidence, gathering of evidence, these aspects of the prosecutor's work. It's like building the case. Since the issues of settlements is a legal question or interpretation, so the issue of complementarity will be more difficult for Israel to address in this case, because will not see it. Israel will not see it as a violation. So you can't claim it's not a violation and then answer complementarity.
Right. Okay, Sharon, would you like to say a couple of words about the kind of invitation to expand on the analogy?
Yeah. Okay.
Perhaps if you have any other questions or comments to other panelists as well.
Yeah, so Victor, so perhaps, the best point of comparison is the Nobel Prize. And, I don't think that there are a lot of similarity in the processes, and this is not necessarily what I meant. Of course, it's the different conflict. But what is interesting is that after 50 years today, so they managed somehow to make a peace process between the FARC and the state in 2016. And then later on, they created this special jurisdiction for peace that we have, that for me, it's a very interesting body because it's a mixture between a criminal procedure and a transitional justice procedure, but in the same space. And it's really with the optic of ending a conflict and trying to reassemble the different narrative and to move on, but not necessarily with, it's really an interesting court, because then the reparation can be negotiated with the victims and etc. Okay, I won't take the floor for this too much, but all this to say that then the ICC is looking, and even though that they are not like the prosecution as we can imagine that the ICC is going to do, because there is this willing, then so the ICC is looking, and this is a way to trigger those exchange between the peace process, a transitional justice process, establishing a common historical narrative, and a prosecution. So what I meant to say in this is that if with this, we'll open those kind of discussion in Israel-Palestine, I think it's huge. And this is the positive aspect that we can have, because of course we are thinking now of 200 people that cannot go to Europe and are going to prosecute and The Hague and so it's very stressing for everyone, and this is maybe not even the point also of the Palestinians to do this, right? Because I heard, I don't remember, maybe it was you, Victor, or I don't know, someone else saying also the politics of the Palestinian to go there was, even in 2009 when they first went to the ICC, was to stop the violence, right? This was the tactic. So of course the ultimate goal is to have a transitional justice process.
Daphne, I saw that you had a few comments as well about that set of points.
Yeah, sure. Thank you so much. I wanted to kind of second Sharon about some of the things that she mentioned earlier about what does it mean to cooperate with the court, and what does it mean, and how do we interpret Israel's kind of like attitude vis-a-vis the court. And I tend to agree with you, Sharon. I think even though Israel says that it doesn't so-called cooperate with the court, it engages with the court, and it has been this the same policy that's been going on for a long time, going back to the advisory opinion on the security fence that Victor mentioned earlier, where Israel submitted a written statement on jurisdiction issues only at the time, but really addressing some of the more substantive issues as well, and making its views known exactly, making its case, like you said, Sharon, in kind of in indirect fashion. So yeah, I guess you're right. You know, it is trapped in between these two. You know, the willingness to make a case, but at the same time not wanting to do it too directly. I think we can call it an engagement as opposed to a cooperation, and maybe take Israel's declaration to the fact that it's not cooperating then with a grain of salt, because in the end of the day, it does do quite a bit on that end. And like you said, in an unofficial kind of like more discreet way, perhaps. Now, with respect to the transitional justice point, I wonder if this is the right way to look at it, because I wonder if having an investigation like this pending against your politicians and your highest military officials is the right way to convince a state to come and sit down for negotiations. Like, I think us lawyers, we might look at it in a way, but if you were actually asking like a negotiator, you know, would that be, you know, grounds upon which they can convince the decision makers to then go ahead and conduct negotiations? I have my doubts about this. So while I want to believe what you and Robert were saying about this being a trigger for a renewal of the peace process, I worry that perhaps it's not going to work as you guys kind of presented it. And I'll tell you why I have some doubts as well. I have some doubts because some of the cornerstone, some of the pillars of the legal framework that applies to the negotiations and to the relationship between Israel and Palestine is United Nations Security Council Resolution 242, a resolution that was quoted in the United Nations General Assembly, you know, famous resolution that gave Palestine its non-permanent observer state status of 2012, and which is extensively quoted in the PTC decision. But so the General Assembly resolution mentions 242, but the PTC itself does not mention it at any time. And this is really kind of like the foundations, right? And I want to say that even the UN General Assembly resolution 6719 in its last operative paragraph says that, you know, negotiations and a just and lasting peace. So it refers to 242, but it also says that all of the core issues, namely, and I quote, the Palestine refugees, Jerusalem, the settlements, borders, security and water, all of this will be resolved by negotiations. So there are some of these foundational pillars that are, when you omit to refer to 242, it also sends a signal, right? So I think these are some concerns as to whether, in terms of transitional justice, we'll really achieve here via this investigation some of the outcome of that has been achieved in Colombia.
Thank you. I'm officially kind of going to start the question and answer period with everyone in this virtual room. And I've had Dr. Ruvi Ziegler, a friend of mine, a friend of the University of Haifa, and also an associate professor at the University of Reading, eager to intervene since the beginning of this conversation. And I invite you, Ruvi, if you are able to do so, to turn on the camera, and you can speak to us directly or just with your voice, whatever you prefer.
Brilliant, thanks, Itamar. Yeah, I think I just have, so I preempted your kind request, and thanks everyone. This is a fascinating discussion, and I suppose I had two questions. The second of which kind of prompted already a bit of discussion on the chat, but I'll be interested in obviously in a panelist perspective. The first was on that last point that I think Victor was making in his opening comments, sort of the reference to the potential prospective Palestinian elections. And to me, that raised two questions, I suppose. One is, to what extent is there a consensus view in Palestinian societies that the ICC decision is a welcome one, given that it may have very different ramifications for different factions? And the second limb of that is, how likely, if at all, is the fact that it's now a live process going to play any role in the elections themselves? Is it potentially going to affect some of the people who stand for election? Is it going to be raised by one of the parties, perhaps as a success of internationalization of the conflict? So I suppose just commentary on that would be great. So that's one strand of questions. The second was on this date of the start of investigation. So the fact that Palestine joined the court, but then gave retroactive jurisdiction from the day after the kidnapping of soldiers, and that's, at least in the UK, that's been used as an argument to say that the court is biased. Why are they starting the investigation on 13th June? Which of course is based on that dateline of Palestine's jurisdiction. So the question for me, the question was first, if Israel were to join the court, could Israel give the court authorization for an earlier date to start, as you were, the same, or to expand the same investigation? I think Daphne suggested in the chat that the prosecutor may be able to do that themselves. So I know Eyal said in the chat that he thinks it's primarily symbolic, but I'm interested in what is the procedure once you've got an investigation that is premised on that retroactive jurisdiction. What is the process for expanding the temporal dimension of that investigation?
Take this, whatever.
Yeah, I think that if I'm correct, the first set of points that Ruvi made is actually to Victor, and then to you, Daphne, if that's okay.
Sure, no problem, of course.
Okay, thanks for the question, Ruvi, about Palestinian elections and the reaction to the announcement of an investigation by all the factions. So I think publicly, all of the factions, well, the main factions, Hamas and Fatah, have welcomed the announcement, and that may also be it's something that no one can really speak against or criticize. But I think behind the scenes, or there's at least knowledge that the investigation won't affect both sides equally, and of course, the main party that was behind the self-referral and joining the ICC was, of course, the leadership in Ramallah. Now, with regard to the elections, well, it remains to be seen what will happen. But if Marwan Barghouti is going to run, I haven't read the newspapers in the last few days, but there was a story that he might run on a separate Fatah list. And if that is the case, in other words, if there are two separate Fatah lists, as there was in 2006, and if that were to split the vote, you could theoretically have a situation where Hamas wins, not just also in the West Bank, and then you have a more complicated situation, because then you'd have if the elections take place and if they're respected, Hamas in power both in the West Bank and in Gaza, and you have a situation where potentially they would then be the head of the Palestinian Authority, and that will raise all kinds of issues, not least whether existing civil servants in the West Bank would want to work for Hamas leadership, as well as the fact that then if they did become, and this is very hypothetical, did become the official leadership, how that would play out. Would it lead to friction? Would it lead to violence? If that were the case, there's an open investigation. So, I mean, it raises a whole bunch of issues. They're very hypothetical, and I don't want to discuss in too much detail. But you're right in the sense that fundamentally there is, one side is not really being investigated at all, and the other side is going to be investigated. And of course, that's going to create all kinds of difficulties between the two sides, as well as going forward. Although publicly, no one wants to say, of course, that they are against this investigation.
I'll move to the second set of questions in a second, but I just want to share my own kind of thought about this, which is that in fact there is there are allegations that can be advanced against Fatah and the Palestinian leadership. I think specifically with the context of violent interrogations, torture and human and degrading treatment of detainees, much of which has been done in collaboration with Israel, of course. And it's curious, in my view, that there has not been any engagement with that in any stage thus far. And this has been part of what created this kind of asymmetry between Hamas and Fatah. And I have had the opportunity to ask a relatively senior lawyer from Gaza on this issue, and I think that there is a recognition behind the scenes that that might be one other possible development, which nevertheless is not a desirable one, I think, from the Palestinian side. I don't know. This is just a thought, of course. But I guess we need to also move to the other set of issues that will be addressed, which is very much within the scope of the comments that Daphne had proposed to us here. So Daphne, if you would like to respond.
Yeah, sure. First of all, it's wonderful to see Ruvi. It's been a very, very long time. So thank you for engaging us and asking us some good questions. Look, for me, the temporal jurisdiction aspect has been really lacking since the very beginning in either the prosecutor's stand on jurisdiction or the PTC. The PTC was limited by the prosecutor, so it's not really their fault. But I guess it comes from the prosecutor, this idea that even though the Rome Statute asks her to really establish a reasonable basis before she opens an investigation, that there is jurisdiction, and that includes, as per the statute and its travaux préparatoires, temporal jurisdiction, she has not done so, and she has lumped together all the acts that come under her jurisdiction as a result of the declaration under Article 12.3 of the Rome Statute, so the retroactive, referral of competence, and the one that is prospective under the Palestinian ratification of the statute as of comes into force April 1st. So she's lumped those two sources of jurisdiction together, and without any explanation, without any attempt at examining whether that raises any kind of unique issues, because this is quite an interesting situation there to have these two sources of jurisdiction, even though not the only time. But I think she should have addressed it, and I think she should have addressed the date, like you said, Ruby, that was chosen by the Palestinians are the start date for the court's jurisdiction, which is June 13, 2014, the day after the three Israeli teenagers were kidnapped and murdered in the West Bank. So clearly this, when we talk about strategy, by the way, Victor, this was done, for a reason, to kind of like take out the acts committed on June 12th from the scope of the court's jurisdiction. Not only legal, per se, but definitely with a, a clear political or, I guess, general objective to exclude those acts from the competence. Now, what could be done in this regard? And here, I think we are once again, in uncharted territory, because so many of these issues come up for the first time, and this is exactly why you're raising them. And I see you shaking your head. So yes, we don't really have an answer to that. The prosecutor has never modified the jurisdiction ratione tempore, right? But could she do it? She could probably find good legally sound justifications for doing so. But you know what? To some extent, I'm not even thinking or saying that she should do it, that she should modify it. But at least she should acknowledge that choice is a willful choice to exclude certain acts that might be relevant to the investigation from the scope of the investigation. At least acknowledge it, even if you're not changing the scope of the jurisdiction itself. So to me, until someone here, some responsible adult, is going to address the issue of temporal jurisdiction, we don't really have the reasonable basis to proceed with the investigation.
Excellent. Thank you. All right. So I do not see right now, at least if I'm correct, a question from the floor that hasn't been addressed within the chat. I'm wondering if anyone wants to follow up on what has just been said. If not, I will present another question from my own, any one of the panelists. Okay, so I guess I would like to perhaps go back, if I may, to some of the points that Robert made earlier in his short presentation with regard to what I take to be the difference between an international court and a domestic court in terms of presentation of evidence. And the point made, if I understand correctly, is that it is somehow easier to present secret evidence, classified evidence to a domestic court than to an international court. And that presenting such evidence to an international court creates significant national security concerns that do not exist otherwise. And following up on that, which I understand was not a issue that you were able to kind of conclude or argue wholly within the frame of time, but I'm wondering, with regard to that, if you can say a little bit more in terms of what difference that makes for an international criminal investigation. Because in first hearing that, I guess my response, and perhaps others felt the same way, is that, well, this is kind of the point of complementarity. So if the government is willing and able to prosecute, to hold investigations in a bona fide and effective way, then they don't confront these problems of classified evidence and so forth. But if that doesn't exist, then the legitimacy of the interest is somehow questionable or diminished, because the opportunity to do so without having that national security concern has been somehow forgone and not picked up. And I'm sure that you have a good kind of set of thoughts about this, but I was wondering how you think of it, and you know, what is the legitimacy of raising that claim for a government that has not taken the steps that international law and international criminal law requires from it to take in order not to meet such investigations?
Okay, so first of all, I had no time to proceed. That can be or maybe just one of the examples from the tension. I brought it as an example for the tensions that may arise further down the road. Okay, there could be others. I haven't had time to go into it, such as I was intending to speak about a operational debrief and the fact they may raise evidentiary issues further down the road. It goes further to the ability, or it goes to access to the territory, to witnesses, to materials. I was strictly looking at the issues of gathering information, the ability of the prosecutor, and the interest of the states on the road. Complementarity is the question: what would be enough or satisfy the issue of complementarity if the prosecutor is just given a blank note, or like a 2-sentence letter which says, okay, we've checked that, we don't think there is a problem, we have information saying that it was a military objective and it was proportionate. Will that satisfy the issue of complementarity? I'm not sure that it would. So I want to bet that some of the cases that we'll see now in those letters that may have to do with things that the military advocate general has already addressed in some way, this way or another, and still may be included in an investigation. So the question is, what will satisfy the issue of complementarity? Then these issues of national security can be raised, as I said, not only at this point or at that point of a decision to investigate. They can be raised further down the road when more information or relevant information may be needed to be disclosed during the proceedings. So it's not only at the beginning, but further down the road, it can be an issue. And yes, states are rightfully very keen about keeping the information which sometimes may risk lives in the hands of people that they can trust in a way, or at least have some ability to prosecute, or they're under Israeli law in some way. There's no there is information that Israel will not share with its closest allies that may be very, very relevant, and showing this to people which are not part of the judicial system in Israel may be an issue as a fact for the state. This is what I think about it.
Excellent, thank you. And I'll move, with your permission, to another follow-up to the talk that Victor gave, in the opening statement that Victor gave, which also kind of raised my curiosity. And I think that everyone can everyone that wants can intervene on this. I think it's most appropriate for Victor to intervene on this, but perhaps others have also thoughts. So as you described it, the Fatah movement primarily has kind of made a bet on international law. It regarded it, as you described, in some suspicion originally, and then with a somewhat haphazard set of circumstances, was led itself to put many eggs in that basket. And I think that with the decision on jurisdiction now and the way that it recognizes statehood, it really reached a kind of peak in that process. At least in my mind, there is a risk here, which is that the promise is not substantiated by power on the ground. And I will speak, from my own kind of perspective right now and say that in a reality in which there is actually one state that controls the territory, recognizing Palestinian statehood might further entrench a kind of illusion that the peace process along the lines that Sharon has suggested is a real possibility right now. And in that regard might not be such a wise political move to make, and might have, as I said, significant risks. So to make a long story short, my question to you is whether, how do you assess this kind of bet on international law, whether it was willful or circumstantial? Has it been beneficial so far for the Palestinians? And does it hold in store real promises for material change in the future?
Thank you for the question. It's a difficult one to answer. I suppose the benefits or potential benefits of it, again, sadly, are mostly hypothetical, but it's seen as a form of accountability for crimes, for justice, if there's a prosecution, and also deterrence in the sense that, well, if you look at it optimistically, there hasn't been another major scale conflict in the Gaza Strip since 2014. On the other hand, you're right to say that nothing has really changed on the ground, and there is always the danger that there is disillusionment. If there's not already disillusionment, there is in fact a lot of disillusionment already. And of course, joining these, initiating these cases also, I mean, it enables the leadership to show that they're actually doing something when in fact nothing really is changing in terms of day-to-day life in Gaza and the West Bank. But I think there's a feeling that there's been too much impunity for too long, and something has to be done. And even something that's aspirational or in the distance, something that's optimistic is something worth striving for.
Thank you. I see Charles Shamas's hand, and I want to give Charles also an opportunity to speak. Charles is also an expert on the IHL issues that are in question here, and is listening, I believe, probably from East Jerusalem today. Charles?
Thank you. This has been a fascinating discussion to listen to. And I wanted to put a couple of 2 cents in on top of Itamar's, on top of yours last comment. Okay. First of all, I want to address the issue of complementarity. And then I want to address the issue of territoriality, which you raised, actually. There's a big difference between saying the state establishes its qualifications, the complementarity conditions are met because it applies the same rules, versus it interprets and applies them similarly, versus it effectively implements them, which is ability and will, perhaps. Okay? I think that there's some value to, in fact, trying the complementarity question itself, which is maybe something that has to occur, over this process. Certainly, with respect to settlements, perhaps with respect to military justice as well. The court is going to have to assess complementarity based on not whether or not rules are accepted, but whether or not they're interpreted and applied equivalently or adequately. Okay? This is most relevant to the settlement process. As I said, it could be relevant also to violations of the law governing the conduct of hostilities. The advantage of doing this may also accrue to all of us, because even though the territorial scope of the jurisdiction is limited to the occupied Palestinian territory, the territory under the jurisdiction of the state of Palestine, or allocated to its jurisdiction, if not under it effectively, the findings are findings which have very substantial political consequences for the policies of the State of Israel, whether you look at it as a single effective state within the entire territory. And in my view, the political accountability, which is a significant outcome of an effective process involving the ICC, the question of political accountability is very well served by determining that the state applies and interprets these rules incompatibly or in a non-corresponding fashion it's not a question of will, except the will to interpret. So that's the political argument and the political evaluation that may come out of this. And secondly, that even though the scope is limited to the occupied Palestinian territory, the state of Palestine, the policies that are under scrutiny are policies of the state of Israel, which it applies, as you indicated, throughout the entire territory of former mandatory Palestine. So in my view, the complementarity, the scrutiny of complementarity can be extremely productive and can be a trial within the trial, and maybe the most consequential trial of that would take place through this whole process.
Thank you, Charles. Sharon?
Yes, thank you, Itamar. I just want very quickly to maybe react of your comment and Daphna. So Daphna, I think that I also agree with you actually when you say, it's not really healthy when a court is triggering a peace process, this, of course. And Itamar also, you are mentioning, but I'm not necessarily speaking about a peace process. It's a bit more a transitional justice process, so it may be a bit different. But of course, it's all related. So it's the idea, and of course, perhaps it's not for tomorrow, but I'm just thinking a little bit for the future, I mean, why are we sitting here and discussing it anyway, It's in order to find better solution for a situation which is not good. So the idea of a transitional justice process is that you are doing a transition. So it's not about doing a peace accord that will reflect the main power that we have. Like if you think about some of the failure of the Oslo Accord and etc. So it's not the idea to do a peace process with those relations of power and then we move on. The idea of a transitional justice process is to have in our head question of accountability, question of peace, question of historical narrative, question of future for our kids, different questions that we will need to see them as a whole. So of course the ICC is one of the two, one of the body. It's not, it in itself. But what I'm saying that because everything is so close and there are really no discussion of nothing for many time, for long now. So maybe this decision of the ICC, I'm not saying that it will cause the peace process, of course not, but maybe it can trigger a new discussion, and a reflection and an action at the end of the day, instead of continuing to bring this Israeli-Palestinian fight from especially the lawfare and all those things, into the ICC, is just a way to think more positively and creatively, to think about the future of this land and its people, and when I say its land and its people, we are all in this, Okay, so this is, but of course, I'm also realistic, and of course, Daphna, it's not about doing it, and I agree with you. And also, Itamar, it's not about doing a peace process with the difference of power, but it's to start working together of what could be.
Thinking about the future of this land and its people seems like a good, positive, perhaps optimistic even, point to kind of declare this, the end of this meeting. I have to say for myself that I learned a lot from each one of you. And I hope that others that have been with us also enjoyed this. I hope that we also have opportunities to continue this discussion and related ones about, indeed, transitional justice as one of them. So with that said, I'm going to say goodbye now to everyone. Thanks again.
Thank you.
Thank you.
Thank you very much.